Did you know that 7 out of 10 Americans who have medical bills say that they have to lower their spending on food in order to avoid a medical bankruptcy? Navigating our highly complex world of healthcare and health benefits leaves many people feeling like a snowball in, well, you know where. I'm Josh Butler, healthcare consultant and advisor to more than 150 employers around the country, and this is A Snowball's Chance in Healthcare, a show about restoring hope in healthcare. Join us as we discuss ways you can lower your healthcare and benefits costs, how companies are winning the healthcare and benefits battle, and how hope is being restored to this community and communities across the country. Hello again, everyone, and welcome back to another edition of A Snowball's Chance in Healthcare. I'm Josh Butler, the host of this program, and I'm the owner and co-founder of Butler Benefits and Consulting. We are a boutique healthcare consulting and brokerage firm located here in Amarillo, Texas. And I'll tell you, folks, we're in the midst of a blizzard. Yes, we do get blizzards in Amarillo, but not a literal blizzard. Not quite yet, anyways. But we're in the midst of a healthcare blizzard, ladies and gentlemen. It's dark, it's cold, and you can't hardly see anything in front of you. But that's what this program is all about. It's about bringing people and bringing organizations out of the middle of that blizzard. And this program is about sharing information and solutions to give you a snowball's chance in healthcare. And I'm excited for today because it is the last episode of 2022. I've really enjoyed doing the podcast so far. I'm already planning for season 2. We've had some amazing guests here in season 1, and we're going to wrap it up today with a bang. And I've already, like I said, I'm looking forward to next year. But we're going to wrap things up with some great guys today. We're gonna do this in a 2-part special. And so instead of just one episode, the season finale is going to be a 2-part episode with the 2 guests that I have here today. And our first guest that's on A Snowball's Chance in Healthcare today, he's an urban dweller from Philadelphia, Pennsylvania. He's a crazy guy. And when he isn't snow skiing or fly fishing, he's holed up in a coffee shop reading dictionaries and thesauruses. But he's one of the smartest guys that I know. He's the CEO of Highlight Health and the president of Next Gen Benefit Advisors, Josh Spivak. Thanks for coming on the program today, buddy.
Thanks for having me, Josh.
Hey, is it true that you like to go to coffee shops and read the dictionary?
I do, because I need a little noise when I read. I can't do it in quiet, so it's my office with a coffee shop.
Is it true that you like to snow ski and fly fish?
I love it, absolutely, but haven't had as much time as I'd like these days to do that because there's so much fog in healthcare, but absolutely love those 2 things.
Well, I love talking to you. We play phone tag quite a bit these last few months, but I love to snow ski as well. So I'm looking forward to getting some of that in here at the Christmas break. All right, my second guest, he's also a partner and he's also an advisor for Highlight Health as well. We're going to talk about Highlight Health in part 2 of this episode, but he's also the president and founding partner of Benefits DNA. He is a previous guest on A Snowball's Chance in Healthcare. And he is Benefits DNA is a consulting firm also in the Philadelphia and Hershey, Pennsylvania area. He's a great dad to his 2 young boys, and he is a genuine hater of firecrackers, ladies and gentlemen. Justin Leader, welcome back to A Snowball's Chance in Healthcare, my friend.
It's a pleasure to be back, and I'm just glad that we're not in the same location and you don't have any of those M80s.
Oh man, we took a trip it's been a couple of years ago now, folks, and we was a bunch of guys, and we're all a bunch of pranksters, and we all got together and went to Lake Texoma, and we tormented Justin for 3 days with firecrackers and just throwing them under his feet and in the bedroom and all kinds of stuff. So, but anyway. He took it in good fun, but I did find out he's a genuine hater of those black cats. So, all right, guys. Today I'm looking forward to getting into this conversation. I think it's a great way to close out the year. And like I said, folks, we're going to make this a 2-part finale since both of these guys are badasses. And I want to talk about this lawsuit that dropped a couple of weeks ago because it involves your clients up in the Northeast. As a matter of fact, it involves 2 labor unions that are up in the Connecticut area, and they have sued Anthem, Blue Cross Blue Shield. And, you know, these are your clients, correct?
They are.
Yep. So
Yep.
let's just kind of get into it. And there, like I said, one's a bricklayers union, I believe, and another is a sheet metals worker union. Do I got that information right, Justin, Josh?
Yes.
Correct.
Yes,
Awesome.
sir.
Okay. Well, not everybody knows, and as a matter of fact, probably no one that listens to this show here in the Texas Panhandle knows that that these two unions filed a class action lawsuit against Anthem Blue Cross Blue Shield 2 weeks ago in Connecticut, and both of these unions are self-funded; they are self-insured. Okay, and they've both levied claims against Anthem Blue Cross Blue Shield that involves Anthem denying them access to information, access to data, and we're going to jump into that. But I've read this filing, Josh and Justin, and it's amazing to read your experience of what you guys have gone through and the longevity of this thing, of just asking for what we feel are simple, standard things that should belong to any self-funded plan. And the stonewalling that's gone on is really, really eye-opening. And so I'd love to just kind of start out and preface our conversation today and remind the audience that in past episodes we've done here on this program about how important it is to not only get your health plan data and gain access to your health plan and your claims data and things of that nature, but also working with people who know how to analyze it, they know what to look for, they know how to audit these types of data files. And so we're going to discuss why these two unions felt it necessary to bring a lawsuit. But if y'all could just start and just share a little bit with the audience about, what led to this, what were you trying to accomplish, and why were you interested in this data in the first place?
Yeah, Justin, you want to go first, or you want to go first?
Yeah, I'll start. Listen, I wouldn't be as smart as I am today, and I'm not that smart, but I have a little bit of intelligence thanks to people like you, Mr. Butler, and thanks in part to my partner, Mr. Spivak, and this mission of understanding the why and the how healthcare has gotten to the point that it has. So a few years ago, the bricklayers had entrusted in us the honor of being their advisor regarding health and welfare benefits, a job that I know you take seriously and we take seriously. And I don't think you can make prudent decisions as a plan or health plan without having access to certain information to make a judgment call. And ultimately, the things that have really empowered our passion outside of just systemic change and a better outcome, lower cost, increased affordability and accessibility of healthcare for plan participants, has been this mission of what more could we be doing, and in turn, what do our plans know and how they've been educated on how to navigate the system. So with highlight with what we're doing, we've taken it as a personal mission to try to uncover and understand this data. And based on the last time I was on your show, the laws have really stepped up and helped provide us with a platform and firm footing to ask more pointed questions and not live in fear, or not even fear, but be helpless to these entities that say this information is not for you. Your clients, they don't need this information. They just have to kind of take it on the chin. And really, it's transpired and gotten to a point where I think we've taken the first step in really pushing to understand and evaluate the intent of these laws and feel pretty confident about what they state. And you're going to see more and more people follow suit down this path, unfortunately, because legislation is important, transparency is important, accountability is important, but where those fail, litigation takes off. Josh, I know Josh Spivak, I know Josh Butler, you hit it on the head. This guy reads more than any one of us. He understands these laws, I think, better than any other advisor in the country. So for us, it was kind of an inevitable position to be in, to take some form of action, or at least encourage our clients to say, now that you're a fiduciary as a plan sponsor, 402A1 and ERISA, that's a legit thing and concern for you now. there's really no other path or no other option that was left on the table.
Yeah, and Spivak, jump in there and talk about what changed with the law. I mean, there was something that came about, here here recently that really triggered a change in the law where you guys felt compelled, like, hey, legally speaking, Anthem, you got to give us our claim data. You got to give us this information. Sure. What changed in the law that prompted you guys to say, hey, now we've got some legality behind us?
Yeah, sure. Absolutely, Josh. So in, December 27th of last year, there was a regulation passed called the No Surprises Act and the Consolidated Appropriations Act, and that made modifications to ERISA, and that made modifications to requirements put on a plan sponsor / plan fiduciary for obtaining data, understanding that data, and making sure that agreements, and I'm giving you a real high level, Josh, not to get into the weeds, make sure at a high level that these agreements that you're entered into in this arrangement with whether it's Anthem or Aetna or Blue Cross or whomever it is fair and reasonable. And you're not squandering and you're not wasting, employer or employee dollars, right? So there's all kinds of teeth within these regulations that enforce you to do that. And by virtue of an employer of a self-funded plan not digging into this data and understanding what they're purchasing and what they're spending the money on, it puts them in harm's way because they could potentially have liability with an employee, right? Think about it this way. You're entrusting your employer to provide benefits for you, and that employer is doing a less than stellar job with your money and your contributions. That's not okay, so that there's liability there above and beyond wanting to do the right thing. So there's a lot of teeth put into the regulations. And what we simply did, having been involved with these groups that did file this lawsuit, it's a shame that it had to happen. No one wants to sue anybody. It's very much a shame, but think about it. If you buy a car, right, you're going to do an inspection. If you buy a house, you're going to do an inspection. But what about with your hospital claims? You're not allowed to do an inspection? That's the component of Highlight Health, where we inspect and we research and we look at claims to make sure fair and reasonable and everything's right. So this lawsuit would not have happened if A, data and information was given, right? Which is, if you're spending $10 million or whatever, you're spending millions of dollars on something, you want to know what you're getting for it, right? Of course. So show me the data, show me the information. That's fair. Forget about a law. That's just common courtesy when you're doing business with somebody. But healthcare has got the big cloud of snowballs. So yeah, right. That's a concern. But so it's not only that, but then when you do look at the claims and you do see data, you see anomalies within those claims about how much is being charged, what's being paid. So as a responsible steward of money, you can use fancy words like fiduciary, i.e. the F word that you referenced earlier, or just say, it's I'm spending my money on this. I want to know what I'm getting.
Absolutely. And these modifications,
these particular plans ran into a roadblock in trying to find out where their money was going, and they took action, right?
Yeah, but let's be very, very clear with the audience about why they felt they had to take action. It wasn't because I'm going to back up a second. You were talking about these modifications and these regulations and the things with the No Surprises Act and the Consolidated Appropriations Act. These are modifications and regulations, Josh, that impact the employer, the plan sponsor. They're not aimed and targeted at the insurance carriers. So why did the unions felt like it was necessary to bring action against the carriers when these modifications to the regulations are strictly pointed at the plan sponsor, the employer?
So twofold. First reason, A, is forget about all the legal mumbo jumbo. Where's my money going? I want to know. And finally, there's laws that say I have a right to know where my money goes. That's number one, right? So that's got nothing to do with legal. That's just common courtesy, right? I refer to it as common courtesy. Number two is from a liability standpoint, right? If I don't do this and one of my employees gets pissed off and gets a hold of the wrong lawyer, guess what? That plan is in jeopardy of having a lawsuit filed against the plan.
The plan is in jeopardy.
Absolutely. And if you look at history, 20 years ago, this is what happened in the 401k world. And as people, 401k, as lawyers say, you know, we pretty much cleaned up all the 401k plans, not all of them, but most of them. So what's the next frontier? Health plans, right? Health plans are the next frontier. And it's a heck of a lot easier to find a disgruntled employee to go after their employer than it is to have an employer go after an Anthem, or not go after, but in this instance, right? So I think all of us on this call today, we represent employers and the employees that they serve through their health plans. So it's logical, but those are the two big reasons: money, economics, liability, money, economics, right to know where the money goes. And also, I don't do these things. I don't do it right by the law. I'm exposed.
You bet. Justin, jump in there. I saw you wanted to add to that.
Personally liable, right? So think about that in plain language. What's a fiduciary? It's a person or organization that acts on behalf of another person or persons, that puts that person or person's interest ahead of their own, with a duty to act in good faith and preserve the trust between them. That's plain language fiduciary, end period. So how can you be a good steward and abide by these rules if you don't ask these questions? But we all know that you're only as intelligent as your advisor allows you to be. A lot of folks don't know to ask these questions, and there's a lot of folks.
Can I jump in, if you don't mind me interrupting, Justin? It's not only asking the question, but then it's getting the answer. And if you don't get the answer that's responsible, keep questioning and keep questioning and questioning, and then something will happen. Either you'll get the information or it'll end in a lawsuit.
Or you get the data, then what the hell do you do with the data? Let me use a Spivakism. So what? Now we have the data. How do we dissect it and understand what the hell we're looking at?
And we're going to get there. We're going to go in that direction, but I want to back up a second because you were talking about that F word again, fiduciary. And obviously the plan sponsor is the fiduciary, but I've read this brief. I've read this lawsuit, and, you know, under ERISA, okay, the plan sponsor is, the courts are not just going to find that the plan sponsor is a fiduciary in this situation. I mean, this lawsuit also names Anthem as a fiduciary to the self-funded plan, that they have fiduciary responsibility to the plan as well, because they have contractual engagements. And even though their contracts say they're not a fiduciary, I don't see how any court or any judge could say that they're not, clearly, because they have discretionary authority and control over the plan. Yes or no? Agree or disagree?
1000% agree. 1000% agree. I mean, you know, for those people that are on this listening to this that are in the healthcare business, how do you know what something's charged? How do you know? Okay, you got a healthcare claim and it costs $100,000. Why does it cost $100,000? Where's the bill? Where's the backup? Where's the data? Is it right? Is it wrong? Where's that contract the insurance company has with the provider organization?
Right. I just want, you know,
we're going black hole.
Yeah, and we're going to get into that black hole because I think that's the most intriguing thing about y'all's experience of what happened in the months where you were requesting this information. Justin, take us through for a moment where because the way I read this is that the initial request came through your Blue Cross Blue Shield or your Anthem representative that worked for Anthem, and it started with you, where you just reached out and said, hey, the plan is requesting this ABC data set on our claims, and they were basically told you what?
Yeah, and there's certain details regarding the pending litigation that we can't get into in the complaint that'll obviously make its way through the system. But the long and short, it's a battle that we all face as advisors on the daily, or for any covered service provider that's trying to do right by the plans that they're representing. We're just making simple data requests. We want to validate what you're telling us is true, and not using one of the people that you have on your payroll or one of your auditors, or, you know, is the data actual factual, like we talked about previously, right? So we want to check the work. But going back, much like any one of our clients, it's just making that simple request. What are billed charges? What's allowed? Give us specific data regarding these claims that these providers have charged the health plan with, and what discounts have been applied. Let's actually do our due diligence in ensuring that you are abiding by your contract that we've agreed to. And I can say it's in the case, there are hundreds of emails back and forth where every request was met with a no, or maybe, but there's going to be contingencies. You're not able to do X with said data. So I think it's frustrating, but it's nice to see the DOL and the government start to get behind, okay, there's a problem, there's opaqueness, we need transparency, we need to shed light. And one of the biggest and most exciting things that has happened recently was with the laborers in Massachusetts versus BCBS of Mass, where the DOL put out a note and said, in that instance, in that case, we consider BCBS of Massachusetts a fiduciary because they have discretion over plan assets. That's a big deal. And that has implications across the board for everything that we're touching.
Huge deal.
Yeah, and let's talk about that for a minute. So let's go back to this, your clients, these two unions, they're ASO with Blue Cross Blue Shield. And for people that don't understand that in the audience, that's ASO stands for Administrative Services Only. So as many people know, you can go to a big health insurance company like an Anthem, and you can say, we want you to administer our plan. We want you to be our administrator of our plan. But at the same time, we also want to lease or access your PPO networks, and therefore you're accessing their PPO network discounts. And so let's move into that territory a little bit, Josh, and talk a little bit about how y'all were able to get some data out of maybe not Anthem, but out of the TPA that the union was using, where you could do some auditing, at least some level of auditing, because I read here in the brief that y'all were able to get claims data and see that your union clients were not getting the discounts that other Anthem groups were getting at hospitals and at care providers in the region. So that's another huge reason we tell people to get their claims data, is just to see if you're getting the promised discounts. And in your union's cases, talk a little bit about that. Y'all discovered that they weren't getting some of the discounts that were guaranteed to them.
Yeah, so essentially one of the things that we're doing is, advisors to the plan and service providers to the plan is making sure claims are being paid appropriately and efficiently, right? So even though we've had trouble getting a complete data set from the payer, there was a series of data that we did receive, right, relative to certain claims. And, we went through that data, we synthesized the data, we looked at it, we matched it up against what their contract said, and things didn't add up. So we questioned it, right? We questioned it. And then we want to dig further, and perhaps there's reason for all of this, and there's an explanation for all of it, but without all of the data, we can't find it. Yeah, I mean, you see situations where there's a hospital charges or a provider charges $50 for something, and somehow the employer gets a bill for $80. Go explain that one. Maybe there's great explanation for it, but show us the data that backs it up.
Yeah, and with the data, it just appears like there's no rhyme or reason to their methodology behind repricing the claim. And so I want to wrap up, that we're drawing near to the conclusion of part one here, because I want to get into in part two here about some other specifics. And I obviously want to talk a little bit more about Highlight Health. But I want to wrap up, because we've been focused on why, this lawsuit was brought, and this was from the complaint itself. As a result of Anthem's failure to share the plan's claims data, plaintiffs are hindered in fulfilling their fiduciary duties to monitor Anthem's performance and ensure Anthem is repricing claims in a prudent manner, or that its fees are reasonable. But go ahead, Justin, comment on that as we wrap up part one here.
So other fiduciary duties, you have a duty of loyalty. You also have a duty of monitor. If you hire or delegate, you have to watch what those vendors are doing. You need periodic reports and reviews that you provide, not just self-reported information from them. And you have to establish a formal review process at reasonable interviews. And in this case, they're failing their fiduciary obligations to their plan because the vendor isn't allow them to do those things.
That's right. And this is why these unions had to act. This is why they felt compelled to bring this lawsuit. They were not getting the information that is required for them to be good stewards, to be good fiduciaries of their plan. And guys, it's information and strategies and things like this that we're gonna continue in part 2 in just a moment. But this is the kind of stuff. Tune in next week when we do part 2 because it's this type of information that gives you a snowball's chance in healthcare. God bless and have a great day.
Thank you all.
You.